Hello, everyone, and thank you for attending the webinar this afternoon. I'm Peter Ford, and presenting with me today is Megan Lehman. For those of you who haven't listened to our webinars before or are not familiar with our firm, Plero Mazza is headquartered in DC, and we have an office in Boulder, which is where Megan and I work. Many of the companies we work with are small and mid-sized government contractors, and we are most known as a government contracting firm. However, in addition to government contracting, we do offer a full range of legal services, including corporate, labor and employment, and litigation matters. So we're going to go ahead and get started. If you have any questions as we are talking, please don't hesitate to just send them. However, we may wait until the end of the webinar to address them. And if you have specific questions that you would feel more comfortable just emailing myself or Megan, please, again, feel free to do so. So Megan and I frequently assist small businesses in drafting, amending, and negotiating operating agreements, bylaws, and shareholders agreements, so your governing documents. And when this exercise involves a government contractor, it's a good marriage of our government contracts and corporate practices because it requires that we navigate the corporate issues with an eye toward federal requirements. And this is especially important when the company is bringing on a new owner, as there are a number of issues to consider, some of which are small business related, while others fall into the corporate bucket. And that's really what we want to discuss today, that being the issues you need to consider if you are planning on bringing on a new owner. So here's just an overview of what we're going to be discussing today. We will touch on why you may need or want to sell a minority stake in your company, notification and approval requirements that may be triggered when you undergo an ownership change. We will also discuss amending your governing documents and the importance of ensuring that the amended documents comply with the ownership and control requirements of the small business programs, 8A, SDVOSB, and woman-owned. And then lastly, we will spend some time talking about how you really do need to plan ahead when you're bringing on a new owner so that the company and the qualifying individual / majority owner are protected if things happen to go awry and you end up going through what we refer to as a business divorce. And with that, I'm going to turn it over to Megan.
Thanks, Peter. So kind of the first thing we wanted to touch on is why would you want to consider bringing on a new owner? It's a big decision that all companies may have to make at one point or another if they need to raise capital. So if you want to bring in an outside investor as a way to raise working capital, that's an option is to do that through an ownership change. You could also reward an employee for good work who's been with you for years, who you want to bring on as part of your ownership in the company. But when you do so, there's certain things that you want to make sure you're still complying with when you're bringing on a new owner, such as affiliation concerns. You don't want to do anything that would jeopardize your small business status, or if you have any other certifications, just by bringing on an owner. So we're going to talk a little bit more about what type of control and ownership requirements you're going to need to still comply with to ensure that your company remains small or certified. Something you also want to consider is, are you bringing on a new owner as an individual or is it an entity? If it's an entity, that kind of brings with it just another level of analysis that we should go through. There's other things that you should consider, whether the other owner or entity has control in other companies, and whether there's any issue about your company being affiliated with this new owner or new entity. And then you should look at how much ownership you're comfortable with giving up. Assuming that the new owner or entity is not disadvantaged or doesn't qualify your company for its certification or small business status, it should be 49% or less. If you're giving up majority ownership, that's a whole nother issue that we should talk about on a separate note. This presentation is focused more towards giving up a minority ownership, and which you're comfortable giving up in that. And while we're focusing on what happens when you do give up ownership and bring on a new owner, that's not something that you absolutely have to do. If you are concerned with working capital or needing some additional funding, there's other options that you may have as well, towards getting an investor or towards getting additional capital, such as debt. You can get a loan. And if you are a small business and are worried about a bank or another financial institution giving you some type of loan, the SBA has their 7A business loan program. So they'll actually work with lenders to provide loans to small businesses. So while the SBA doesn't give out the loans directly, the SBA will help kind of with that arrangement, and they'll guarantee the loan as well, if there's a concern that your company wouldn't be able to do that by itself. You also have the option of phantom stock, where you're not actually giving up stock in the company, but you could be receiving an investment for a payout guaranteed at a later date. So while you wouldn't be giving it up currently, it could vest down the road. So
yeah,
once you
I'll just add a couple things there. And again, on some of those other considerations, particularly that's affiliation, for example, like Megan mentioned, what we're talking about here today is selling a minority stake in your company. And doing that in and of itself or by itself shouldn't necessarily create an affiliation problem, but it could be problematic if, for example, this minority owner just so happens to be an individual with whom you have multiple common investments. And this one now additional common investments is enough to trigger an identity of interest and affiliate all of the companies. I guess it could also be a problem if this minority owner happens to be one of your immediate family members. And on that basis alone, they could say the minority owner and the majority owner are treated as one and the same. And so anything else that your minority owner / family member owns would be considered an affiliate of your company. And then what's not up here is you need, and this is something that you really should be consulting with your CPA, accountant, or tax advisor about, but that there may be certain tax implications when you undergo an ownership change. So that's just something just to keep in mind. I mean, we're really focusing here on the legal aspect, but just food for thought.
Thanks, Peter. So once you've decided to go forward with the ownership change, there's quite a few steps that need to occur after or during. One of the first things we want to talk about is just making sure that you do your due diligence. So looking to see what approvals or notifications you need to get beforehand or after. So you should look first at all your contracts to see if there's any notification or approval requirements. Specifically, FAR 52-215-19 talks about notification and ownership change. It typically comes into play when there's certified cost contracts. So you should just look at your contracts and see if you need to notify the contracting officer or any other entity, and if you have to get approval. Although it's rare, it's possible. So you should always check your contracts to see. Something else to consider is if the new owner is a foreign entity. If it is, and you do cleared work, that could be an issue. So while it's okay, there's certain breaks that we would need to draft into the corporate documents to ensure that the requisite split is there so that the company and or your employees can continue to maintain their security and facility clearances down the road. And that's kind of at general administrative things. Looking more specifically at the small business aspect, if you're an 8A, you have to get SBA approval before you can go through any ownership change. The only exception for that is if the owner is incapacitated or has died, then you have 60 days after that event to get SBA approval. But typically, you'll need to get SBA approval if you're 8A before you go through with any formal ownership change. So that's just definitely something to keep in mind. If you're CVE verified and you're substituting one veteran for another, currently the regulations actually say that you need contracting officer approval beforehand for a novation, but we've confirmed that this actually should be treated as any other change in ownership, meaning you still have to notify and fill out a new application for CVE verification as an SDVOSB, but that can occur after the ownership change. It doesn't have to occur beforehand like it does in the 8A world. However, if you're substituting one SDVOSB entity for another, then that would be looked at more as a novation where you're actually changing the entity that's performing on a contract. Then you have to go through the entire novation process and get approval for that as well. If you're hub zone, you have a requirement to notify SBA of any material change, and a change in ownership would be considered a material change. You do so by emailing the SBA and of the ownership change, and they can request any additional information at the time. If you don't think you qualify anymore, then you can withdraw as well, but just the change of ownership would require notification. For WOSB, you should also upload any new ownership documents, so evidencing the stock change, the amended and restated bylaws or operating agreement. You should upload all those new documents through the certified.sba.gov website. And kind of as a side note to that as well, if you are currently WOSB and you do self-certify, that is going to be removed soon. We don't have an exact date, but it is coming. So while you can currently self-certify, it's important to keep an eye on that because soon you will no longer be able to self-certify. So once you have to go through the certification process and you do have an ownership change, that's something that will need to be cleared with the SBA as well.
So real quickly, just to piggyback on what Megan was saying about the SBA approvals and the CVE notifications, if you're thinking about doing an ownership change and you're an 8A, just keep in mind that the first place that you should be going in terms of bringing this to the attention of the SBA is your district office, and specifically your business development specialist. And it's something that you want to kind of put in front of them before the parties start working on all of the deal documents, because it depends based on the district office, but some district offices don't want to see you coming to them with an approval request with documents that have been executed. Some offices just want to see draft documents, but there are other offices that would prefer to see executed documents. But within those executed documents, there's language sprinkled throughout that says, the closing of the sale and purchase is subject to SBA approval. And then also just keep in mind that, these things don't get approved overnight, at least these SBA 8A ownership change approvals. So it is kind of a waiting game. And there's a lot of information you're going to have to provide. Regarding the CVE, if you look at the regulation on ownership, it just says if you change ownership, you got to file a new application. You really have to look elsewhere in the regs to see that it says if you undergo a change in ownership, you have to notify us within 60 days, and then you submit the new application. And they call it a new application, but it's almost like you're undergoing a re-verification, which if you've gone through it, it is kind of like a new application. But they're really just vetting the company under this new ownership structure. And then lastly, whether it's an 8A approval change or a CVE-VA approval change, while that approval is pending, or while CVE is vetting the new ownership structure, just keep in mind that you're still an eligible 8A firm, and you're still an eligible SDVOSB, and you're showing up in the VIP database.
So, in addition to ownership, we often receive questions for, well, do I have to also recertify my small business status if I have undergone an ownership change? And the SBA regulation states that recertification is required where the small business acquires or is acquired by another concern. So if Peter owned a business and I came in as a new owner, I am not another concern. In the SBA eyes, it would be an entity. So if there's an individual acquiring the ownership, the recertification isn't triggered. However, where it gets a little tricky is where you're being acquired or acquiring another entity. So that kind of goes back to a couple slides ago where we talked about, is the new owner going to be an entity or is it going to be an individual? If it's an entity, you have to look at whether it's being acquired or is acquired. And then in that case, that triggers additional requirements regarding novation. And if a novation is required, you have to recertify your status within 30 days of the novation approval. For example, if you're SDVOSB, not necessarily CVE verified, but just an SDVOSB, if you go through an acquisition or merger without a novation, you still have to recertify within 30 days of the transaction becoming final. And if you no longer qualify as an SDVOSB, although you were qualified on the contract initially as SDVOSB, going forward, the options cannot count towards the procuring agency's SDVOSB goals. So there's certain things just to keep in mind regarding recertification when an ownership change occurs that involves another entity.
Okay, so let's say that you've made that business decision and you've now decided to take the plunge and bring on a new owner. As part of that purchase and sale transaction, one of the key transaction documents are going to be the amended governing documents. Meaning, if you're an LLC, your operating agreement, if you're a corporation, your bylaws, and if you have one, a shareholders agreement. From a small business perspective, the amended documents must comply with the regulations governing the SBA's small business contracting programs. Again, 8A, SDVOSB, woman-owned small business, and if you're participating in the VA's SDVOSB program, well, with those requirements as well. And those regulations require that the qualifying individual, again, the majority owner, unconditionally own and control the company, and that unconditional ownership and control must be reflected in the governing documents. Meaning, if you get protested, or if SBA has a basis, or VA has a basis, to question your eligibility, and it's an ownership or control issue, the first thing they're going to be looking at and asking for are your governing documents. So the amended governing documents with this new ownership structure need to be compliant. And so the first thing that we'll talk about, and really quickly, I referenced the 2017 NDAA here simply because if you don't know, as part of the 2017 National Defense Authorization Act, Congress told the VA that you can have your own SDVOSB program, but you can't have your own rules. And what that means is the rules that are going to govern the SBA's SDVOSB program and the VA's SDVOSB program, which is the verification program, whereas SBA's is self-certification, they're going to be the same. And it's SBA that's going to be responsible for crafting those rules. And right now the rules are similar, but we'll get to something a little later where they do differ. So unconditional ownership. So For ownership to be unconditional, the qualifying individual must own at least 51% of the company. So if you're an LLC, this means that the individual must own at least 51% of each class of member interest. If you're a corporation, though, the qualifying individual must own at least 51% of each class of voting stock and at least 51% of the aggregate of all stock outstanding, both voting and non-voting. In addition, the qualifying individual's ownership cannot be conditioned. And what that means is that he or she must be able to sell his or her interest in the company whenever he or she wants to whomever he or she wants. Thus, your operating agreement or your shareholders agreement should not contain any transfer restrictions, such as a right of first refusal, which requires an owner who wants to sell to a third party to first offer his shares to the company and or the other owners before proceeding with the sale to a third party. Another example would be tag-along rights, which in the event that the majority owner wants to sell his majority ownership stake, it allows the minority owners to join in on the deal and participate on the same terms and conditions. And if you're participating in these set-aside programs and your operating agreement does contain transfer restrictions, one thing that you can do and that we do on a pretty regular basis is, instead of just stripping all the transfer restrictions out, is to include a carve-out that simply says that, for so long as the company is participating in these specific programs, the transfer restrictions and conditions on the ownership in this agreement simply do not apply to the qualifying individual. And in our experience, how transfer restrictions are viewed does tend to vary from small business program to program. For example, the SBA's STVOSB program, the case law, and there's very recent case law, it's pretty crystal clear that you can't have any transfer restrictions at all. So something like a right of first refusal, or something as simple as saying, hey, if you want to transfer or sell your interest, you just have to get the other members' approval. That's not permissible and would be viewed as a condition on the veteran owner's ownership, and therefore the company would not be in compliance. On the other hand, in the context of the VA's STVOSB program, and this is one of the issues where the regulations differ, and it's not necessarily the regulations, it's the case law that's out there in terms of how the regulations are to be interpreted. Those types of transfer restrictions, meaning a right of first refusal and tag-along rights, those would be permitted. And what the courts have said is that the way that they interpret the VA's ownership regulation is that you can have transfer restrictions so long as they are commercially reasonable. Having said that, in practice, regardless of what set-aside program we are doing, and because there's really nothing in the regulations themselves that specifically says no transfer restrictions or yes, you can have transfer restrictions, we do tend to err on the side of caution and do something along the lines of what I said earlier about carving out the qualifying individual. So in addition to the lack of transfer restrictions, unconditional ownership also requires that the qualifying individual receive at least 51% of the annual distributions of dividends paid on stock, 100% of the value of each share of stock in the event that the stock is sold, and at least 51% of the retained earnings of the concern, and 100% of the unencumbered value of each share of stock in the event of dissolution of the corporation. So that, in a nutshell, is unconditional ownership. And so now we'll turn to control. So unconditional control means that the management, I think this slide is just mislabeled. It should say control. Unconditional control means that the management and daily business operations of the company are conducted by the disadvantaged individual, which, as you can imagine, is often a hard pill to swallow for a new owner, because he or she, or if it's an entity, it cannot have much say in the decision-making process. And with an LLC, the new owner basically can have no say, because the regulations require that the qualifying individual / majority owner serve as the managing member with control over all LLC decisions. And that goes as far as to require the qualifying individual to have the right to unilaterally amend the operating agreement, meaning the qualifying individual, majority owner, and his new business partner / minority owner are signing up to an agreement that is going to govern how the company is run, how profit is split, and things of that nature. But at the same time, the way that the regs read and the way that the case law interpreting those regs read, that agreement, even though it's signed, it can be literally amended on a whim if the qualifying individual wanted to do so. With a corporation, there's a little more flexibility, and that the qualifying individual just needs to demonstrate control of the board of directors. And for example, with the SBA's SDVOSB program, the veteran owner will be found to control the board if he or she owns at least 51% of the voting stock, is on the board, and has the percentage of voting stock necessary to overcome any supermajority voting requirements. The other way that you can establish control of the board is if the service-disabled veteran, or more than one, meaning service-disabled veterans, comprise the majority of voting directors, either through actual numbers or if state law permits, weighted voting. So what that means is something along the lines of amending the operating agreement. I'm sorry, in this case, it would be the bylaws or the shareholders agreement, may be permissible under some of these set-aside programs where if you're an LLC, it would not. Why they make a distinction, I don't really know, between an LLC and a corporation, but they do. Having said that, that doesn't necessarily mean that the new owner has to take a complete backseat and just be a passive investor. The regulations do allow the new owner to be an officer, he could be a director, he could be both. However, your governing documents should make clear that any position, be it officer or director, that is going to be held by the new owner will always be subordinate to that of the qualifying individual. Also keeping in mind that some of the other control requirements are that the qualifying individual be the highest officer, and also be the highest compensated individual within the company. But again, even so, you still need to be careful to avoid including provisions in the documents that could give the new owner negative control. So what is negative control? So negative control includes, but it's not limited to, instances where a minority owner has the ability under the company's governing documents, again, operating agreement, bylaws, shareholders agreement, to prevent the qualifying individual from taking action on behalf of the company. What that means is you have a negative control problem if the new owner can block a quorum, meaning, and let's just say it's an LLC and the qualifying individual wants to hold a meeting so that the members can act, but the quorum requirement is that both members be present. That could be problematic because in the event the non-qualifying individual / minority owner decides not to show up, then the qualifying individual by himself or herself alone is not going to be sufficient to establish quorum, meaning the members can't act. Likewise, if you have a laundry list of supermajority voting requirements, or not even a laundry list, but limited to just a few extraordinary actions that cannot be met without the vote of the new owner, that's also negative control. So just think of a situation where the governing documents say that if we're going to vote for a matter to pass and for us to move forward with that action, it has to get a simple majority vote, meaning 51%. So normally, if the majority owner has 51% ownership of the company, he or she can pass generally any matter that comes before the members. But if you have certain actions that say, well, that's the general requirement, but with respect to A, B, C, and D, you need a 75% member vote, then that could be problematic, again, because the minority member, if he doesn't vote or she doesn't vote in favor of the matter, but the majority owner / qualifying individual does, you only get 51%, which is obviously short of 75, and the action just isn't going to move forward. So negative control is problematic, because if SBA finds negative control, that means the company is not unconditionally controlled, and therefore you're non-compliant with the regulations. And if you're non-compliant, you can lose contracts, you can be terminated from these programs or canceled, or even worse. But another issue in terms of negative control, and this is kind of just a side issue, is it goes back to what we were saying earlier about affiliation considerations. And if someone has negative control is still viewed by the SBA as control. You have affirmative control and you have negative control. At the end of the day, they're both control. So if the SBA were to find that the minority owner has too much negative control, they could also say, well, he controls the company, and because he controls the company through his negative control, then the company is also affiliated with any of that owner's companies and affiliates. Again, like I said before, the regulations provide very little protections to minority owners. And unfortunately, this does make it difficult for companies who are participating in these small business programs to attract new owners and investors in the first place. And it goes back to what I was saying earlier, is that if you need to raise capital and you can't get a loan from a bank, and let's say your only option is to look towards an individual to help you finance, or an entity who's willing to make an equity investment in your company so that you have that working capital, you got to kind of look at from their point of view, meaning they're putting money and making an investment into the company and getting ownership, but at the same time, they have very little say in what you are going to do or not do with that capital infusion. And again, they're signing up to governing documents that may look one way today, but they may not look the same way, 6 months down the road, if that qualifying individual thinks something needs to be changed. And again, under the documents, he has the power to do so. We are hopeful that at some point, SBA will revise the regulations to make them a little more, quote unquote, business friendly. But for now, they are what they are. And so you need to be mindful of these regulations, and specifically in terms of how they're going to impact your amended governing documents if you do choose to bring on a new owner. So most of what we have discussed so far are the small business considerations when bringing on a new owner. So now we're going to turn to the corporate side of things. So most business relationships do start strong. Owners are passionate, owners are enthusiastic, and they share the same goal of making the company a financial success. But sometimes they end. And for that reason, in addition to small business considerations involving a new owner, it is equally important to plan ahead so that the company and the qualifying individual / majority owner are protected if things don't go as planned and the owners need to go their separate ways. Thus, looking at this from a corporate perspective, your governing documents should contain what's known as a business divorce section, and Megan will speak to that.
Thanks, Peter. So kind of what we first wanted to talk about as far as one part of the business divorce section is disassociation from the company. So while you are entering into this business relationship, ideally for the long haul and to make your company a success, there is a possibility that things could go awry down the road. So in disassociation, you want to create a provision in the operating agreement or the bylaws which would give the company or the remaining member the right to buy out the other member's interest if disassociated. So we also wanted to note that withdrawal is different from disassociation. So under withdrawal, the member is voluntarily withdrawing from the company. They're withdrawing their ownership and interest in the company. So here, for purposes of the webinar, we're focused more with disassociation. So kind of what happens when a member is, for lack of a better term, forced out, and what happens, what will make that occur. So the operating agreement should spell out some certain triggering events for dissociation. So they can be controllable or uncontrollable. It's important to have both because not always will the member or owner do something wrong. They could just be let go from the company for any reason, or there just could be a disability or death. That would fall in the uncontrollable triggering event section. In the controllable triggering event, that would include typically if the member employee is terminated from the company for cause. So, for example, they breached their fiduciary duties to the company, or they did something else with the company that wasn't in line with their duties, or they filed bankruptcy on a personal level. Those are some examples of certain things that you can include in the bylaws or operating agreement so that there isn't a concern down the road, well, I want to fire this person because they stole money from my company, but what is that going to have to do with their ownership interest? So it's important to plan for this down the road if there is an issue, even if it's not something that you anticipate currently when you go through the ownership change. Next, we wanted to talk about, well, okay, you have the disassociation provision, so how do I determine what price is going to be paid for the buyout of the interest or ownership? It should vary a little bit between controllable and uncontrollable triggering events, because if it's uncontrollable and they were just let go because there isn't enough business in the company, or there was a disability or some other incapacitation, from more of a fairness aspect, it should be a little different because they didn't do anything necessarily wrong to be disassociated from the company. They just happened to be disassociated. If it's a controllable triggering event, such as they stole money or they did something else that was in their control, the purchase price is typically a little less. So if it's a controllable triggering event, you can just look to the straight book value by looking at the company's books and records, or you can do a percentage of fair market value, somewhere around 50 or 75%, but it's something that you guys should, the owner should be cognizant of and negotiate up front when you're amending your governing documents, so that the documents say how much you're going to be paid down the road. So there isn't a concern, well, you're not paying me enough. But then how do you determine fair market value? We recommend that the operating agreement and bylaws would actually go so far as to spell out who would be determining fair market value, so that it's an independent third-party appraiser. Because if you cannot agree on the value of the company or the value of your ownership interest, how are you going to determine what price to pay and whether that's a fair price? So it's important to include either the name or a company of a third-party appraiser that you would turn to down the road if you do need to come up with the fair market value of the company, which wouldn't be determined necessarily just from the book value. So it's important to think about those things as well.
Yeah, and thanks, Megan. The one thing I'll add is that, I think more often than not, when, companies are thinking about bringing on a new owner, I think it's just kind of assumed that this new owner is going to be buying into the company, meaning he's making a cash contribution or part of the purchase price that's being paid to the majority owner for the minority owner stake is at least in part a cash piece. But that's not always the case. And again, I mean, you do need to kind of look at LLC law from state to state to see, what can be viewed as a contribution. But in Virginia, for example, you don't have to contribute cash to get an interest, meaning you can contribute past services that you've rendered, and you can contribute an agreement to perform future services. So there doesn't necessarily have to be a cash component, although more often than not there is. But if you think about it, if someone is buying into the company, but they're buying in not with cash, and instead they're agreeing to perform certain services, then you may want to consider, and this goes back to what Megan was saying about disassociation, is tying those disassociation triggering events, or not tying them, but inserting another one or including another one that has something to do with respect to that individual and his active participation in the company, meaning because he has agreed to perform services in exchange for an ownership interest, obviously you want him or her to perform those services. And if that individual is not working, let's say, full-time for the company or otherwise not actively involved in the company's operations, then that may be another event of disassociation. And then, to take it one step further about what Megan was saying about, how you were determining fair market value, and should it be book value if it's controllable, and fair market value if it's uncontrollable. But again, with someone who's not buying into the company with cash, I mean, what happens if you've given him a 20% interest in the company, and 2 months later, this individual who agreed to perform for services just stops showing up, and now you have an event of disassociation. But what do you think you should have to pay him? I mean, maybe there's an argument, at least if your governing documents say this, that if he leaves between the first 6 months, meaning he stops actively participating within the first 6 months of becoming an owner, then he gets nothing. And maybe if he leaves after year 1 or year 2, he gets a percentage of fair market value or book value, but not 100%. Again, just with the understanding that this individual who you are giving your company, a part of your company to, didn't put up any money for it, and instead is just providing services.
So there's just a couple other things we wanted to touch on regarding the payment terms. So while Peter mentioned that typically we're speaking in cash, sometimes when you have to buy out a member's interest, what if you or the company doesn't have enough working capital to do so? So the bylaws and operating agreement should set forth how the interest will be purchased, either through cash, promissory note, or it could be a combination of the two. It should be flexible enough so that you are not set in or committed to one way or another, but you should also specify the types of financing that could occur in case, because you don't know what financial position you're going to be in down the road if and when you have to exercise the buyout. And lastly, one other item we wanted to touch on is key man insurance. just as another consideration that you should provide for in the operating agreement or bylaws. So human insurance is essentially an insurance policy that you take out on the company's owners. It could be key employees, but typically it's owners. It's basically a life insurance policy. So if something was to happen to that owner, the company would be entitled to the insurance proceeds so that the company or the other member would not have to front the money to buy out the interest of the member who has passed on. So it's something to keep in mind as an additional insurance policy in case the company will not be in the financial position to purchase out the interest agreement, or sorry, the interest or ownership, if down the road that needs to occur. So that's just something else that we would recommend to include in the operating agreement or bylaws as another additional protection for the company and the member if you do need to end up exercising the buyout. And I think that's everything, unless Peter has something to add, and we can kind of take a look at your questions that you've been putting in as well to see if there's something that we can answer for you.
No, thank you, Megan. And we do have some questions, so let's just. So there's a question about an asset sale versus a stock sale, and what's the difference? Well, with an asset purchase, that's what you're buying. You're just buying, that's all you're buying, meaning you're buying certain assets of the company, and you're likely assuming certain liabilities that go along with those assets. But you may not be buying 100% of the assets, so there may be a provision in the purchase agreement that says these are the assets that you're buying, but here are a list of the excluded assets as well as the excluded liabilities. So you're not buying everything. It's almost as if you're picking and choosing, but there are times when it's an asset sale, but the assets being sold are basically the entire company. Whereas with a stock sale, you're really getting everything. So that means you're getting the good and the bad, meaning you're getting all of the assets, and at the same time you're getting all of the liabilities. And I think the other part of this question, or the individual is just pointing out, is and this is just this would be a difference in terms of just government contracting, is that if you do a stock purchase and you have government contracts, the name of the company, it's the same company and with the same contracts, government contracts. So what that means is you wouldn't have to go through a novation. But if you do an asset sale and company A buys some of company B's contracts, well, now you need to get those contracts out of the name of company B and into the name of company A. And so in that situation, you would have to submit a novation package. So there's a question here about if an SDVOSB is selling 40% to a mentor, what notices, if any, need to be given? Good question. And let's just assume, and I'm assuming this is the case, that the SDVOSB is also a protege to this mentor, meaning they're in an SBA approved mentor-protege relationship. And one of the benefits of being in a mentor-protege relationship is that the mentor can own up to 40% of the protege, meaning if the protege needs capital, the mentor can invest or make an equity investment up to 40%. And while you are in that mentor-protege relationship, that 40% interest can't be used by the SBA or any of your competitors as a basis to affiliate the companies. But in terms of what notices you have to give, the first thing I would say is if you want to get that benefit, meaning you sell to the mentor 40% of your company, and you don't want that 40% interest to be used against you for affiliation purposes, then the first thing you need to do is make sure that your mentor-protege agreement contemplates that as a type of financial assistance, meaning that it's clearly spelled out in your mentor-protege agreement that to the extent the protege needs to raise capital, the mentor, may or anticipates, making an equity investment of X. So that's one thing. Is you want to make sure that it's actually in the mentor-protege agreement that SBA approved, and if it's not, what you want to do is you want to go back to the SBA and ask them to approve an amendment to the agreement so that you can get that type of assistance in, so that it's under this umbrella now of the mentor-protege relationship and can't be used against you. But assuming that it's in the agreement itself and it's just an SDVOSB, then again, the only ownership changes that get approved by the SBA are 8A ownership changes. So if you're just an SDVOSB and you're in the SBA's SDVOSB program, which is self-certification, arguably you wouldn't have to give any sort of notice or get any sort of approval. If you're in the VA's program, you wouldn't have to get prior approval, but you would have to, this goes back to what we were saying before, is once that ownership change has occurred, you'd have to notify CVE and undergo a new application / re-verification. But other than that, that's really all that's required. The one thing I will say is that, and again, I mean, this whole webinar has been about bringing on a new owner, but this what they call a benefit, the ability to have your mentor own an equity interest in your company of up to 40%. That's a big interest. It's not a majority interest, but it's a big minority interest. And this really goes back to something that Megan was touching on earlier, is do you really want to do that? Meaning you've built this company up, and let's say that you've been in business for 5 years and it's just your company, and now all of a sudden you're going to give 40% to, let's say, a large business that you have to think is going to try at least to have some sort of control over the concern's operations, which they cannot really if you're in these small business programs. So it's a big decision, and I think bringing on a minority owner in general is a big decision, again, because it's your company and it's your equity that you're not giving away, but still that you've built up, and now part of it is no longer yours. The other thing I would say about that on the 40% issue is that exemption from affiliation, meaning it can't be used to affiliate the two companies. That protection goes away once the two companies are no longer in that mentor-protege relationship. So the moment the relationship ends, so too does the protections from affiliation, meaning at that point in time, someone could file a size protest and argue that this mentor with its 40% interest is somehow controlling the company. So just something to keep in mind. And again, I mean, if that's the only source of capital that you have, then you may have to make that decision and sell a part of it to your mentor. But consider looking elsewhere first. And if it's not, your typical commercial lender, good to what Megan was talking about in terms of seeing if you can get into this SBA loan program. How is it handled if a minority partner wants to give their child their portion of the company without any monetary exchange, and the child is a service-disabled veteran? That is a very good question, and it would be more problematic if this were an 8A firm and the ownership was just being gifted. But I mean, that it still could be a potential problem in the VA's SDVOSB program. Again, the reason being is they do want to see that these purchase and sale transactions are truly arm's length transactions. So just giving it away, I don't want to say it necessarily raises red flags, but I think if you know, that transaction was being reviewed by SBA or the VA, I do think it would be scrutinized more so than it would if there was you know, consideration exchanged in exchange for the interest. The other thing that this raises is and I think this is it's not in the SBA's SDVOSB rules, but it is in the VA's SDVOSB rules. And it basically contemplates a situation where you have a family member giving majority ownership of the company, or even selling majority ownership of the company to a family member who is a service-disabled veteran. And the idea being that you know, they don't want to see a company who's just set up to go after VA contracts, and it was set up in a way that, you know, the owner who couldn't qualify it just gave that interest, that majority interest, to a family member who could qualify it. And so when you have a transfer to an immediate family member within 2 years, there's a presumption that the prior owner, let's say it's a father-son, and father's selling the interest, and if that father is somehow still involved in the company, maybe he's not an owner, but he's staying on as an officer or a director, or maybe just staying on for a short duration to provide transition services, there's a presumption that the father still controls the company. And you can rebut that presumption, provided that you can show that the son has the managerial experience to run the company, and that he is in fact doing so. And with that, I think that's the questions. I mean, so there is a question about, is the recording for the webinar available after this session? Yes, and if you also want a copy of the slides, we would be happy to send them to you. You may be able to access them without us having to send them to you. I'm not entirely familiar with the process, but one way or the other.
Yeah, I believe it was given as a handout, but if you for some reason don't have it, just you can email Peter or I, and we'd be happy to get you a copy. But it should also be available on our website as well in a couple days.
Yeah, and like I said, if you have specific questions that you would feel more comfortable, just sending to us directly, feel free to do so. If you have follow-up questions, please feel free to send us an email or give us a call, and we'd be happy to have a discussion with you. But again, thank you everyone for attending, and I hope you found this informative.
Thank you all. Bye-bye.